I have started the meeting. I hope we've got all our participants online. They should all be there now. Maybe if you just want to give us the shout out that you're there, that would be lovely just to know. I can see a few faces that have come or a few screens that have come up.
Yep, can hear you loud and clear.
Excellent. That is great. Okay, we might get started. So thank you, everybody. Now, hopefully we can see our screen here. I'll just make sure that it's there available. Can everybody see the presentation slides?
Yeah, no problem.
Yep.
Fantastic. All right, we'll get started. So thank you so much for being here today. We've got the Public Trustee, Office of the Public Guardian and Palliative Care Tasmania joining us today, and we're going to have a great session talking about the documents that you need to make your choices matter. So today's a very important session and we're very grateful for everyone to join us. Just to let you know that we will be recording this session. So if you do not want your faces to appear on the screen, please make sure your videos are turned off. Looks like most people's videos are switched off, so that should be fine. But yeah, just letting you know that you may be recorded just to let you know. Excellent. Well, I will just want to start by just with an acknowledgement of country. So I'd like to start by acknowledging the Tasmanian Aboriginal people, the traditional custodians of the land on which we gather today, and I pay my respects to elders past and present, and I'd also like to extend that respect to any Aboriginal clients or people who are with us today. We've got, as I have mentioned, we've got a few people here joining us. Firstly, we've got Fiona Sullivan. Fiona, you might just want to put your hand up so people know who you are. Great. So Fiona is the Acting General Manager of Trustee Services with the Public Trustee. She has been with us for 13 years, or over 13 years, I believe, and she has worked in just about every area of our business. She's worked helping people do estate planning. She has also helped support beneficiaries with deceased estate administration, and she's also been leading the team working and supporting vulnerable Tasmanians under administration order. So there's quite a few areas that Fiona's been worked on, and she's sort of going to be a great person to have chatting to us today. We've also got Hannah Butler. Hannah, you might just want to give a wave there too. She's the Manager for Sector Engagement at Palliative Care Tasmania. Hannah is also a clinical nurse with the Specialist Palliative Care Service in Hobart, with 16 years in aged care, community and acute settings. She's passionate about education, advocacy and ensuring people are supported to live and die well. And we've also got Eliza Jones. She is a dispute resolution practitioner with the Office of the Public Guardian, a nationally accredited mediator specialist in elder mediation. Eliza helps resolve disputes around advanced care directives and substitute decision making, and provides community education on crucial topics. So another great person to have here today. And I'm Maria. I'm the Business and Marketing and Business Development Manager at the Public Trustee. I just wanted to let you know that today's information is just meant to be general in nature. It wasn't prepared without anyone's personal objectives or financial situations in mind. We don't know that information. So please just consider what is most appropriate to you before you act on any information that we give today. And yeah, it's always important to make sure that you get your own advice related to your circumstances. Like I said, this video will be recorded so that it will be available after the session. It should run for about 40 minutes and then we'll have some time for questions and answers at the end. If you would like to ask a question, please use the chat function on the side of the screen to put any questions in there. We will try and address those questions as we go. If not, we'll leave them to the end. So we'll just see how we're going with the presentation, because some of that information may be covered as we go through. Just wanted to make everybody just aware to be just mindful of yourself. Sometimes talking about these topics can bring up big feelings, and so it's just important just to be mindful of where you're at, and just be kind to yourself and take some space if you need it. This information will be available afterwards if you do need to tap out for any reason. But I guess today we hope that we can provide some really useful information and some information that you'll be able to act upon and, sort of move forward. Today, or this week, has been National Advanced Care Planning Week. It's an initiative designed to raise awareness, encourage conversations about healthcare preferences. And this year's theme is Making Your Choices Matter, which is I guess, why we are taking on this topic as our webinar today. And we felt this was a powerful reminder to ensure people plan ahead and, understand what documents they need to prepare, as well as making sure, they can may have those conversations and, chat with family and friends about what they need to do. So Fiona will discuss the vital role of the public trustee a little bit later on. She'll also talk about enduring powers of attorney and wills. After that, we'll hand over to Hannah, who will talk about the role of Palliative Care Tasmania and cover advanced care directives. And then Eliza will discuss enduring guardianship documents and the roles and the responsibilities of the Office of the Public Guardian. And then we'll wrap up again with questions. So I'll join you again just to sort of mediate any of those questions that we need to discuss at the end. I guess one of the most important reasons we are here today is about planning ahead, and it brings peace of mind, not just for yourself, but for your loved ones, and knowing that there is a clear plan in place to relieve stress and uncertainty during difficult times. There are many studies that have been taken place which shows over 50% of Australians, including Tasmanians, do not have a will or proper documents in order to articulate their wishes. And that's something that really does need to change. Many people sort of think that it won't happen to them, but unfortunately, we never know, and it's a really good idea to have some certainty. And lots of people just, go, well, I'll sort that out one day. I know there's many studies to say that most people understand that they need a will in particular, but they just haven't got around to it. So hopefully today, again, is another important reminder as to, to take action, make sure your wishes are documented so that there is a very clear plan to reduce that uncertainty, not only for your, for the loved ones left behind. Having those documents in place just provides them a lot of security and understanding about what they need to do. If there are no clear decision makers appointed, families can face legal, financial and emotional challenges, including unnecessary stress at an already difficult time. And if there are no documents in place or suitable family members or friends, the public trustee or the Office of the Public Guardian can be appointed to make decisions for a person if their decision making is impaired due to a disability, accident or illness. But while we provide these essential services, we are the last resort. So it is important to make sure that you prepare those documents in time, well ahead, to ensure your choices matter. And it will also reduce the burden on loved ones and the legal system. All right, well, Fiona, I might throw to you if you want to just talk about the role of the public trustee.
Thanks, Maria. Well, I guess our role is wide and varied, and as Maria mentioned at the beginning, I've sort of got quite a large role that I play here at the Public Trustee. I guess, one of the key services that we provide is obviously we provide trusted advice on estate planning documents. So around the state, we have a service where we have employed solicitors where you can make an appointment to come along and have a will done, including an enduring power of attorney, which I'll sort of touch on a little bit later in a bit more depth about just briefly what those documents entail. We also administer deceased estates when we're appointed as executor. So that's quite a large commercial element, I guess, to the business. So, the Public Trustee's been around for, 100 or 150 odd years. So our will bank at any, here is basically 20,000 or more wills that we currently hold on behalf of people that have obviously trusted us to be their executor when they pass away. So the deceased estate administrations is quite a big part. We also act as an attorney. So once again, where people come to us to prepare an enduring power of attorney document, not everybody has a family member or an individual that they wish to appoint. And so in those circumstances, the Public Trustee is asked to step into that role. And so if required, we then manage a person's financial affairs under the registered enduring power of attorney as their attorney. We also manage trusts. So once again, quite a large part of the business. That trusts basically stem from testamentary trusts. So they're from a will. We also manage court-awarded trusts, obviously from outcomes from the Supreme Court, including monies where criminal injuries, particularly people that are under the age of 18 years, we look after their money for them until they attain the age of 18 years. But I guess when I look at this list, the greater client number that we're currently looking after are basically the people that we support under orders from TASCAT. So currently we've got about 1,242 clients that we support around the state. And for those that are not familiar with TASCAT, obviously a hearing is held and the Public Trustee, amongst others, so individuals, relevant others, can be appointed as somebody's financial administrator if the members of TASCAT deem that the person's basically got an impaired decision-making ability. So if there are no other individuals or family members that the TASCAT wish to appoint, then the Public Trustee basically can be appointed. So that is quite a large area, as I say. Currently, across the board, we've probably got 2,000 current administrations operating at any point in time, of which the 1,240 sort of fall under that TASCAT banner or from that TASCAT appointment. So quite a busy time, or lots of work, I guess, that we undertake at the Public Trustee. Sorry, Maria, I can't quite see there what we've got. Have we got a message coming through? No.
No, haven't got a message coming through. Sorry, I just replied to a message that did come through. So that's fine.
No worries at all. That's just coming up on my screen. Yes, so Maria, I guess that is just basically gives everybody just a very brief summary of the work that we do on a daily basis.
Thanks, Fiona. I think we could probably switch over to Hannah, who will talk about palliative care, what they do, and advanced care directives.
Thank you. Thanks, Maria. Thanks, Fiona. And it's lovely to see Eliza and it's lovely to come together again this year. We've done a few years now where we get to come together and do these webinars. So it's wonderful. So thanks so much for the introduction, Maria. My name's Hannah and I work for Palliative Care Tasmania. So we're your peak body for palliative and end-of-life care in the state. We do a big part of what we do is community information, education, talking about death, dying, palliative care and advanced care planning, but we also do, we also undertake research. We work with our local governments and also federal governments and advocate for better access to palliative care. And the demand for palliative care is certainly growing here in Tasmania ahead of all other states and territories across Australia. So we need to get prepared and have these conversations. So today I'm going to talk about making your choices matter through advanced care planning. And this is an important part to start first before the advanced care directive and all the other documents. So I thought it was a really good place to begin to get together today. Advanced care planning is thinking ahead to make your decisions about your future healthcare and ensuring those closest to you know your wishes. I'll introduce what advanced care planning is, why it's important, and how you can take steps to make sure that your preferences are honoured into an advanced care directive is hopefully what we are aiming for. We don't have a lot of time together today for me to dive into detail, so I'm going to skim the surface and give you a real introduction. So it will be up to you to dive in deeper after the session today, and I'll provide you with information, resources, and where to go to next with this topic. So many people believe it's important to discuss their healthcare preferences, yet many people actually do. And Maria talked about how many people have wills. We also know that 50% of us won't get a say in our end of life care wishes either. But 8 in 10 people say it's important to think and talk about their preferences for care at the end of life. Yet 1 in 4 people have spoken with their family about their preferences, and 6% of people have spoken with their doctor. So these numbers show a significant gap in what we think we should be doing and then what we go and actually act upon. So I hope today that this gets you to think about don't wait, and also to build these compassionate communities when talking about this, and planning for our future healthcare is just a normal part of what we do. So if I'd like you to think about someone close to you, maybe it could be a partner, parent, or friend. So just have someone in your mind right now. Imagine if they couldn't speak for themselves and doctors came to you and said that you need to make a decision about their care. So would you know exactly what that person that you care or love for would want? Or would you be left guessing what medical treatments to choose for them? Now, if you flip that around, what if something happened to you? So you're now the person who have lost decision-making ability or can't communicate. Would the person closest to you know what you would want and what choices to make for you? That's why advanced care planning matters. It's not just about you, it is really about the people who are caring for you, that your loved ones and the people around you. We know that making decisions about healthcare under stressful situations can be really difficult, and we want to try and avoid that. And that's why it is so important. In a nutshell, advanced care planning helps you plan ahead for your future healthcare, and it also includes end-of-life care. It's a voluntary and ongoing process that ensures people know your wishes even if you can't speak for yourself. It gives you a chance to talk with the people who matter most. Now, this could be your family, your friends, your enduring guardian, your loved ones, and your healthcare team. And you get to talk to them about your values, your wishes, and also treatment preferences. Advanced care planning can also include appointing a substitute decision maker and choosing someone that you trust to make decisions for you if you lost the ability to do so. And Maria already said that could be due to injury, illness, or a disability. And Eliza will talk more about substitute decision making a little bit later. But advanced care planning can also include formally documenting your wishes. And here in Tasmania, we have the Advanced Care Directive. Advanced care planning is important for everyone, no matter your age or health. So it's not just for older people and it's not for those just living with cancer, but it does become really important as we get older. If we've been diagnosed with a life-limiting illness, if we have been diagnosed with cardiovascular disease, lung disease, renal disease, Huntington's, just to name a few. It also becomes important if we're at risk of losing our decision-making ability. Now, that may be an early diagnosis of dementia, perhaps. It also becomes important as we near the end of our life, or if we are living alone and we don't have anybody to advocate for us. And hearing the statistics this morning in a webinar I was watching around loneliness, and as we age, 50% of us will be single and living on our own. So it becomes more important to document our wishes more than ever. Advanced care planning should be part of routine care We know that when we start these conversations, when people are well and before there is an urgent need for decisions to be made, then the people at the heart will experience better outcomes. They'll have better care outcomes, end-of-life outcomes, but so do their family and their friends. And that's really important too. So we know that advanced care planning doesn't just benefit you, but it does benefit your family and your health professionals. It keeps you in control of your healthcare when you can't speak for yourself, and it makes sure that your wishes and preferences are known and respected. It also takes the pressure off your family having to make decisions in really tough situations, and it avoids them having to make also decisions that maybe you may not have made for yourself as well. Healthcare professionals will know exactly what matters most to you and respect your treatment preferences. And this can also prevent unwanted medical treatments, maybe unnecessary treatments to transfer at hospital, or any other interventions that may not actually benefit you. So it's an all-round process that benefits all of us. So one way to make your choices clear so that we're all on the same page is by completing the Advanced Care Directive. So you can see here the document up on your screen. So this is a legal document where you can record your values, your healthcare preferences, and your medical treatment choices. If you scan the QR code, it will take you to the Department of Health website where you can download the Advanced Care Directive along with an information sheet to help you in filling out this form. You can see it is a 4-page document, but I've only just put the first page up. But the first part here is about your values and your preferences. What makes your life worth living? Where do you want to be cared for? This is the stuff around what matters most. And this is why it's important to start with this and think about it in the advanced care planning process. In the Advanced Care Directive is a legally binding document here in Tasmania. I can't remember if I said that or not. Sorry if I did. And it includes 2 types of provisions, binding and non-binding, and I'll explain these a little bit more in detail on the next slide. We also really recommend you using this particular form from the Department of Health the Department of Health website to document your wishes. It is really important to also note here that each state and territory in Australia has its own laws, different documents, different legislations, different terminology around advanced care planning and substitute decision making. So terminology may differ. So it's really important that you familiarise yourself with Tasmanian laws and the documents and our wording. And if you are planning to travel or move interstate, please check the requirements of that state or territory. It can be really confusing, different states and territories with different terminologies. You don't need a lawyer to complete an advanced care directive, but you can certainly seek legal advice if you would prefer. By completing an advanced care directive, you make your choices matter. So in Tasmania, you can complete an advanced care directive as long as you have decision-making ability. It's important to note that every adult is assumed to have decision-making ability unless it has been proven otherwise. The advanced care directive itself only comes into effect if you can't make or communicate your decisions or you've lost decision-making ability. Up until that point, people should be talking to you about what it is that you want. And you can also change your advanced care directive as long as you have decision-making ability. Once you've lost that decision-making ability, then you can't go and change your advanced care directive. It helps your doctors and loved ones or substitute decision makers understand what matters to you. And without it, your family might face those difficult decisions that I already talked about without knowing what you truly would want. You can include specific instructions about the medical treatments that you want or you don't want and under what circumstances. So in the previous slide, I mentioned binding and non-binding provisions. So if I can give you a couple of examples to help understand this, we'll start with the binding provisions first. So these are specific instructions about the medical treatments that healthcare professionals must follow. So if you state, I refuse to be put on a ventilator or refuse CPR or many other things that we suggest you talk with your health practitioner about, your doctor, then doctors, nurses, health professionals must respect that decision if if that situation arises. Whereas the non-binding provisions are the preferences and wishes about your care. They reflect your personal values, your priorities. They're what matters most, things that we've started to talk about. But healthcare professionals are not legally required to follow them. So an example, it might be about the music that you want, people visiting, or where you would like to be cared for at the end of your life. There's a lot more to this, but I'm just trying to give you a little bit of a snippet into this process.
Hannah, sorry, I've just got one question that's come through on the chat, which you might be able to cover in a moment, but it was does it need to be renewed every year? And how often, I guess, does it need to be renewed? So that was a good question. I thought that was asked.
That's a really great question. There is no requirement to review your Advanced Care Directive every year. However, your preferences and your decisions may change. You may want different things. So it's recommended that you review this document and you talk about it with the people that matter most to you, because things may change. You may decide that you want treatment or you don't. So all the people that were in your life who were helping you, supporting your decisions, may no longer be there, and your family situations may change. So certainly there's no requirement to review it, but it's a good idea to do so. In Tasmania, you have the flexibility to write, speak, or document your wishes in any way that works best for you. So to learn more about creating an Advanced Care Directive in Tasmania, I really encourage you to visit the Tasmanian Civil and Administrative Tribunal website, and there's wonderful fact sheets on their website that can help in that process, as well as you can also call them and ask some advice. You can register your Advanced Care Directive as long as it's on that form that I showed you before with TasCat to ensure it's accessible whenever needed. So if you haven't given a copy to somebody important, it can sit on a secure portal. However, even if you don't register it, it is still valid. So I'm just going to say that again. You can register it with TasCat. It's a good idea to register it. However, if you don't, it is still legally valid. There is no cost with registering it through TasCat either. And there's more information around what you need to include if you are going to register it on the TasCat website. I'm just going to pop up on the screen there. You can see these are value statements. So I'd like you to just have a look at these value statements on your screen. And I'd like you to pick out 5 that resonate most with you around if you couldn't speak for yourself or what you may want at the end of your life. So I'll just give you a couple of moments now to have a look there and see what might be important to you or what matters most if things changed and you were given a limited amount of time. And if you want to put them into the chat and share as you go, please feel free to do so. And there may be things on there that aren't important to you and you may have something else, and that's okay too. I did a session just before this one, and the main things that came out here were being as independent, ensuring my pets and animals were well looked after was a very big something that everybody held very close to them. So I can't see the chat in here. I'm just going to have a little look if anyone has popped in anything in there. But these value statements you can get from Palliative Care Australia website. So you can head to their website and you can start this process of thinking about what matters most to you and the values that might be important to you that can help you then do your Advanced Care Directive. So up on the screen here, these are the things that you can talk to your people about, your loved ones, your health providers. If you don't talk about these things and you don't document them, you may miss an opportunity. Someone might never ever know that you don't want country music playing, or that you want to be cared for in your home in Huonville, or that you want your family and friends around. So these are opportunities. And if you don't talk and you don't tell someone, they may be gone. So I really do encourage you to start here and have a look at this booklet that you can download for free. So starting the advanced care planning process may feel overwhelming, but taking that first step is absolutely crucial. And here are 3 steps that you can take to know that your choices are known and respected. So be open, reflect on your values and what matters most to you. Be ready, talk with your family, your loved ones, appoint a substitute decision maker or appoint an enduring guardian, and be heard. Write it down, document your choices, and share that with your family, your friends, your enduring guardian. Upload it to TasCat if you've got an ACD. Upload it to your My Health record, pop it on the fridge, and make sure that the people who matter most to you, who may be supporting decision making, know what your wishes are. Maria, how are we going for time?
We're at the halfway mark. Maybe we just show this very quickly and then...
Yeah, or we can wait to the end, and if there's time, I'm happy to do that.
How about
too.
we do that?
Why don't
Maybe
we do that?
wait to the end.
So I think overall, my message to you is your choices today will matter tomorrow. It's really important to start the conversation with those closest to you. So your family, friends, healthcare team. Consider appointing an enduring guardian, and really document your wishes. Consider documenting those wishes into our Tasmanian Advanced Care Directive to ensure your preferences are known and followed. If you need support, start with your GP or your healthcare worker, whoever's involved in your care. That is my first go-to. Talk to them. They understand your illnesses, what your illness will look like over time, and provide you with accurate information. Head to the Department of Health website to pick up the fact sheet, the information sheet on advanced care directives, as well as you can download the advanced care directive. The TasCat website have wonderful fact sheets and information around advanced care directives and also enduring guardianship and much more. The Office of the Public Guardian, of course, the Public Trustee, Tasmanian Legal Aid, also COTA have many estate planning things. There's lots of support out there for you. You can head to our website and we can offer information and support in advanced care planning and connect you to where you need to go. Advanced Care Planning Australia has a lot of information for you completing this process if you're in a substitute decision maker role or you're a healthcare professional. And PAL Help volunteers in the South also provide support around advanced care planning as well. And there is a lot more to learn, and usually we spend a few hours diving into this. So I hope that I've given you enough information to spark your interest and curiosity, and I really do encourage you to learn more around advanced care plannings and especially the Advanced Care Directive. And if we've got time at the end, we can show the video.
Thanks, Hannah. Yeah, hopefully if we can have some time, we can watch that video at the end. Otherwise, we will be sending out a link because it is a lovely video just to sort of showcase why it's so important to prepare these documents. And yeah, go forward and make sure your family understands your wishes. But just to keep moving on, Eliza, we might move to you to talk about the Office of the Public Guardian and enduring guardianship.
Lovely. Thank you, Maria. Yes, and thank you everyone for joining us today. And yes, I'll just come back to that, sorry. I'm going to be talking mostly about the Enduring Guardianship Instrument today. And I'm just going to flag right at the beginning that the fact sheet from TasCat, which is the Tasmanian Civil and Administrative Tribunal, has a very useful fact sheet, and everything that I'm presenting today generally comes from that, so that will help if you want to go back and read that. And as Hannah sort of done, there's the websites that are also going to provide useful information for you, so there's nothing sort of really new on that. I do need to emphasise, Hannah brought that up, but when we talk about enduring guardianship, it's really important to note, that message, that all states and territories have different terminology and legislation relating to these concepts or legal frameworks. So very important that this is specific to Tasmania, and to be alert to the fact, if you have mainland friends or legal advice that's from the mainland, they may use different terminology. But here in Tasmania, when we're talking about enduring guardianship, this is what you're going to hear today is the Tasmanian one. So what we're going to look at, and just before I do this, this is a fairly wordy presentation, and there's a lot of information to take in, and I'm not going to make any apologies for that, because there is a bit to understand about it. But again, just knowing that you'll have a copy of, you can look at this slide at a later date, and the fact sheet is available as well. But understanding, well, what is an enduring guardian instrument? For starters, the word instrument refers to something that is legal. It's not something that you play for music, it's illegal. So an enduring guardian instrument is a legal document that allows one person to appoint another, which is the enduring guardian, to make decisions for them if that person is unable to make those decisions themselves because of a decision-making impairment. So this is the actual instrument or the document itself, and I'm going to, as I go through this presentation, I'm also going to talk about where you can get these documents and just some basics around how to register it. So, but that's what the document looks like. Why are we going to have an enduring guardian? And again, we're picking up on the themes that have come through. It's the certainty about who is going to make decisions about personal matters for you if your decision-making ability becomes impaired. So again, this is about that theme about choice. Because if there is no enduring guardian in place and a decision needs to be made, and you've got a decision-making impairment and there's no enduring guardian or anyone else, perhaps for medical decisions, a person responsible may make those for you. And the person responsible might be your spouse or a close friend, or alternatively, if there is no other legally appointed decision maker, the tribunal may need to appoint a guardian for you to make those decisions, such as where you live, the services that you receive, and who visits you. Now, when we talk about when they say may appoint a guardian, this was raised earlier, the public guardian is the guardian of last resort. So before then, the tribunal may well be looking at if there's a family friend or someone close by, an unpaid carer, who can take on the role as private guardian. And even if there's still nobody, then that's when the public guardian, which is the office that I work in, may well be appointed. But it's very important to note that those guardians are only appointed if there's a clear need to do so, and that need generally refers to the fact an important decision needs to be made and there isn't someone already appointed, such as an enduring guardian. And just I wanted to give a little visual, because most people get it confused between what's an enduring power of attorney, which is what Fiona will talk about at the end here, and what's an enduring guardian. So just to give you that snapshot so you can perhaps remember it visually, personal decisions is about the people, is the enduring guardian. Money decisions is for your power of attorney. And then the advanced care directive is for health decisions. So just to sort of come back to that, to reiterate that the decisions the enduring guardian can make, again, it's personal decisions. So it'll be your healthcare and medical treatment, where you might live, the supports and the services the person receives, and who has contact with and under what arrangements. And another little thing to be aware, to be alert to as well, often an enduring guardian might be when we talk about that one around services, can be very helpful to have in place if you no longer have decision-making ability for things like the ACAT assessments, going through my aged care, any of those assessments that need to be done. You need to have someone who's an appointed legal representative, which is like an enduring guardian. So be really mindful about that. It is an important instrument to have in place. So what the enduring guardian is not going to make decisions about, as we've said, it's not going to be about your money, but also who you vote for. They cannot make or change your will or the advance care directive, arrange marriage on your behalf or anything against the law. So now, how are you going to do it? So this is when we get to the nutty business of it. How are you going to do this? So first of all, you've got to be over the age of 18 and must have that decision-making ability to make the appointment. But there's another sort of understanding that is very important that needs to be in place that a person has, and it's called the nature and effect of the instrument. So what that means is that the person who is, making the enduring guardianship, was, doing the document, understands sort of the extent or the limit of the power that the document has, or the instrument has, and how that power is exercised. And I'm going to talk a bit about what that means in the next slide, so just bear with me. But also when the power's exercised, limits on how that enduring guardian can make decisions, that they understand that they can revoke the instrument, and that they really understand that they can't oversee it once they lose decision-making ability. So there's a lot to what that understanding is that we refer to in terms of their decision-making ability. So again, how are we going to appoint it? Sorry, just get rid of that off the slide. Is that to complete the form, you go to Service Tasmania, and on the front page of their website, they've got a whole little box, a lot of boxes that are on there, and you look for the Justice, Crime and the Law one, and then the next one says Help in Planning in End-of-Life Documents, and that's where you can find the form. You need to go and get it completed, have it witnessed, and then it needs to be registered, and that's where I'm going to go to the next slide. Once you've completed the document, you also then have to complete the cover sheet. And when you go and lodge it at a Service Tasmania shop, and there's where what the fees are, and you need to keep up abreast that those fees do go up every couple of years, but that's what it is currently. Service Tasmania then send it off to TASCAT, that Civil and Administrative Tribunal, who then register the document, and they will then return the originals to you. This is a very important process because the document is not legally binding unless it is registered. Now, the other thing is you can prepare these documents with your lawyer. That's something I'm doing at the moment. So they fill in a lot of this and they'll do the registration for you. But just to know, it must be registered to be in effect. So who are you going to appoint with your enduring guardian? So they've obviously got to be someone who is over the age of 18. And the next 2 points are very, very important. They've got to be willing and able to take on the role. When we talk about able, that means that they can be called upon easily. So, for instance, if it's your daughter and they're living, they might be living in Europe or the United States, and they're really going to be able to sort of respond in real time. Or perhaps they're really busy, their life is such that they might have young children, and so that able is a very important thing to consider who you're appointing. And also the next one, do they really understand the responsibility that goes with the role? And when we talk about the responsibility is that they need to be making decisions that are consistent with your wishes and within what's within the instrument. So they really need to understand what that responsibility is. You can appoint a single person. You can also appoint joint or alternative. If they're joint, that means there's 2 people together. They really need to be able to get on well together because they will be making decisions together and make the same decision. The alternative guardian is someone who comes into place if the first person that you've chosen isn't able to perform the role. And really, that's very common to put an alternative in. You're not able to choose someone who's a professional administrative capacity involved in your medical treatment or care, and you can't choose the public guardian to be your enduring guardian. So I've sort of alluded to the fact that sort of enduring guardians, how they make decisions. So this is it's really important to note that how enduring guardian, the whole operation is legislated under the Guardianship and Administration Act. And how an enduring guardian makes decisions is contained not only in the instrument, because there's a section there which I'll talk about in a minute, the conditions upon the decision making, but the enduring guardian must also make decisions in accordance with the Guardianship and Administration Act. And so what it means is that the person who's making decisions on your behalf are consistent with what your views, your will and your preference that are also expressed in the enduring guardian instrument. And I suppose to give you some clarity around this is that in years gone by, people made decisions in someone's best interest. Oh, it's in mum's best interest that, you know, she doesn't have this medical treatment, or it's mum's best interest. That is no longer the case. The Act changed in September of last year, so 2024, whereby now a person's will and preference, what it is that their values, or put it another way, the appointed enduring guardian ought to make decisions on your behalf that is the same that you would have made, the same decision that you would have made yourself if you were able to. So in the document, on the enduring guardian document on the second page, there's a thing of conditions of the appointment. So you can give directions and conditions to that enduring guardian that they must comply with when they're making decisions on your behalf. You can give as many conditions as you like, or none at all, and they have to be really clear, because that enduring guardian needs to make sure they're following your wishes. And it's really recommended that you do seek legal advice about the way that you express those conditions. There's important sort of nexus between an enduring guardian and advanced care directives, in that if you've made an advanced care directive, there is a spot on the form for you to indicate that you've done this and if it's been registered. And whatever's in the, you might have made some conditions in your enduring guardian instrument, the advanced care directive takes precedence if there's an inconsistency between the two. Also, when the person is taking on the role of enduring guardian, they must sign that they've seen that advanced care directive and they understand the contents of it as well. Can you change your mind? And of course, but there must be decision-making ability to make any changes. So you can revoke it, you can amend whatever the conditions are, you can appoint a new enduring guardian. However, those changes need to be registered and there are new fees for that registration. And also, if you've made that change, you're revoking, the new appointment needs to state that you have revoked the previous instrument. Sometimes though, however, despite, doing a really great document and choosing the right person who really understands your instructions are or the conditions in it, sometimes there can be disputes that arise, either actually about an advanced care directive, but in relation to an enduring guardian, but also the actions of a private guardian that's been appointed by the tribunal or a private administrator. And that's the role that I have as a dispute resolution practitioner in the Office of the Public Guardian, where we might be able to help and resolve those conflicts. And generally, it is usually people perhaps not understanding that responsibility about how they make their decisions that the conflicts come about. So it might be a very low, bit of explanation about what the responsibilities under the Act are as a guardian that can sort of sort it out. But it might be something a little bit more serious where family members don't necessarily agree. It might be mum said, oh, look, I really want to be able to stay home, and other family members want mum to go into a residential aged care. So I'm trying to work out that sort of thing. But in essence, it is always that at the centre of all of it is the person themselves and what their wishes and preferences are. So that's sort of a brief summary, and we're going to have some time for questions afterwards. So then we'll leave those for then. Thank you, Maria.
Thanks so much for that, Eliza. I think we'll keep moving on so we can sort of wrap up in the next sort of 10 or so minutes. So Fiona, can you take it away with talking about enduring powers of attorney and wills?
Yes, thanks, Maria. I guess, yes, so enduring powers of attorney, and just following on from the information that Hannah and Eliza have already provided, is basically a document that you enter into specifically dealing with your finances. So unlike those two documents that we've just heard about. This is just solely around your finances. And once again, what I'm referring to is basically a document that has been prepared and registered in Tasmania, because quite rightly, as Hannah and Eliza previously mentioned in relation to their particular documents, every state and territory around Australia also has its own requirements regarding enduring powers of attorney. So that's something that's quite important to remember. So I guess, when you're thinking about entering into an enduring power of attorney, of course, you must be 18 years of age, and you also must have the mental capacity to obviously make the document. It's a fairly straightforward document that can actually be completed by the public trustee, for example, by solicitors, private law firms. You can also, if you are confident, you can also go on to the Department of Natural Resources and Environment Tasmania. If you go onto their website, they also have a downloadable enduring power of attorney form that you can also obviously complete and lodge yourself. So if you're confident and capable of doing that, I guess, from what we see at the Public Trustee, the most important aspect, I guess, to remember is, or to focus on, is really who are you appointing as your attorney. And one thing that we regularly see is that whoever you do decide to appoint as your attorney, please make sure that you've actually reached out to them and spoken to them about the particular appointment, because from time to time, the public trustee is appointed by an individual that has been appointed as an attorney, who unfortunately just doesn't want to do the role, may work or live remotely, and basically just doesn't want to be involved. So really important that you focus on who you're going to appoint as your attorney, and more importantly, that you also check with them. With an enduring power of attorney too, of course, that is only a document that is in place whilst you're alive. Once you pass away, then we turn our attention to the terms of your will. So that's something else to remember. Here in Tasmania, for an enduring power of attorney to be recognised, it must be registered with the Lands Titles Office. So this is certainly a requirement that is completely different, as I say, to other states and territories where you can actually deal with people's assets without a registration occurring. That is not the case in Tasmania. You have to have your document prepared, appropriately witnessed, including being signed by the attorney as well, and then it is registered at the Lands Titles Office. It then obviously gets placed with a registration number and a stamp, which is then recognised by banks and other financial institutions that you need to deal with. So that's really quite important. There is a fee which is indexed every year. The current fee is $169.23 to register an enduring power of attorney. So not a cheap exercise, I guess, but as I say, but certainly a very important document that you need to have in place. So without that document, without having an enduring power of attorney in place, and in case that you suffer a medical episode and become incapable of managing your own financial affairs, the only way forward is then for basically your family members, your spouse, close friend, would be to make an application to TASCAT, the Tasmanian Civil and Administrative Tribunal that both Eliza and Hannah have also referred to. An application will then need to be made to TASCAT, and then it'll be up to TASCAT to basically make a decision as to who the best person is to manage your financial affairs. So certainly, we certainly encourage, I guess, when we're doing these presentations around the state, we certainly encourage, as part of the estate planning document process, a lot of people focus on wills, but we definitely encourage the enduring power of attorney to also be entered into, just in case, which basically gives you, I guess, peace of mind that the person that you want to look after your finances, and it can be more than one person. I might say it can be another. You can appoint two attorneys, for example, but whether it's one or two, they are people that you've specifically chosen or personally chosen to be your attorney. In contrast to if it obviously ends up down at TASCAT, then it really is up to the tribunal members after a hearing's held as to who they think is best placed to look after your financial affairs. So I guess with an enduring power of attorney as well, and this is not unusual, sometimes you might appoint one person and then that person passes away. So then you can basically you can revoke an enduring power of attorney. Once again, that's a prescribed form that you need to complete and obviously pay a fee. And then you can then either then leave it at that, which obviously we don't recommend. Then you would obviously then enter into another enduring power of attorney appointing somebody else. So if you need any more information regarding enduring powers of attorney, the Public Trustee on its own website, we definitely have our own fact sheet around just the document generally and certainly things that you need to consider when entering into such a document, as does Tasmania Legal Aid on their website. They certainly have a section on enduring powers of attorney. So I'd certainly encourage everybody to check out basically either of those websites if you need further information. I'm then going to briefly just have a chat about wills because I'm very conscious about the time. Once again, with a will, I suppose the most important part of a will is that you need to not only be considering, of course, who you want your estate to go to, but it is the role of the executor. Once again, we are regularly approached by individuals who do not want to be the executor. Was never really discussed with them that somebody was going to appoint them as executor. And that is really quite important because the role of the executor is extremely obviously, it comes with a legal responsibility, but it is quite time consuming insofar as a deceased estate administration. The expectation and the role that you need to complete as executor is quite time consuming. So if I'm a person, if you're an individual wanting to make a will, you certainly should give due consideration to who you are going to be appointing as your executor. Whether it is an individual, more than one person, that's quite okay. Obviously, it's the same with the enduring power of attorney. If you are appointing more than one person, please make sure that those people get on well with one another and they're not going to be at conflict when we get to a point in time when your will or enduring power of attorney needs to be relied upon. That really is quite important. I guess that's where, if I reflect on the estate planning documents that we complete at the Public Trustee, we do have a role to play, particularly in the space of blended families, which of course are more and more common in this day and age. And basically, because we are impartial, we're not favouring somebody else's children over somebody else, or an individual's not favouring, somebody else's children over somebody else or family members. And so that's where they come along to the Public Trustee. And obviously we step in and we fulfil the role of executor. So I guess if you're going along, if you're coming to us, there is a little booklet that I promote quite heavily. This is something that an marketing initiative that we've come up with, but you can sort of do your own, but we're more than happy to share. There is a personal record book, which basically says, in our case, simplifying your life. I can't stress enough, whether it's a booklet like this, whether it's your own memo booklet at home, please create a booklet or record information in a booklet that basically reflects your financial position. So by that I mean your bank account numbers, maybe, if you're going to be recording passwords, then you need to make sure that you are keeping your booklet in a safe place. But the more information that you can record down in relation to your finances, the easier it is then for an executor to basically administer your estate. once again, when I reflect on our estates that we administer here, we often have executors come in, particularly if it's family members who, and particularly when a person has died unexpectedly, when we start discussing about what a person's affairs or financial affairs look like, and information in that regard. Sometimes it's just quite overwhelming, of course, particularly if it's a close family member that is the appointed executor or beneficiary or whatever it may be. So it's really important that when you're thinking about your estate planning documents, that you also think about not only an enduring power of attorney, not only a will, but also making sure that you've got all of your information that's going to be relevant, financial information, that's going to be relevant when either of these documents need to be relied upon. So I guess getting back to a will, as I said right at the beginning, the public trustee plays quite an important role in our community, just speaking about wills and enduring powers of attorney. So, we'd certainly like people to come to us. It's a service that we provide and it's one of our core service lines. But aside from us, you can go to a private lawyer. You can also use a will kit. You can also seek the advice of Tasmania Legal Aid. With will kits, though, we get often asked about this. Will kits are not are a good product, if you like. The problems that we see with will kits, though, is that they are basically not completed correctly, and so which then, of course, may cause the will then to be invalid. So if you are somebody or friends or family that are relying on a will kit, please try to encourage them to make sure that the document or the will kit has been completed correctly, because for a will to be valid, needs to be dated, needs to divest all of your estate, it needs to be signed by yourself, needs to be witnessed. There's quite a criteria around what constitutes a valid will. So just generally speaking, if you have friends or family talking about will kits, really important that that you basically just remind them that it is completed correctly. I suppose if you in Tassie, if you die without a will, which unfortunately does happen, probably more than we would like to think, there are specific, which is the case, I might say, all around Australia, but once again, I'm just reflecting on Tasmania law. In Tasmania, it's known as the Intestacy Act of 2010. So basically that law directs how a person's estate should be distributed or needs to be distributed without a valid will being in existence. So really important, I guess, that a will is drawn. And the other program that we've also been reflecting on as well regarding wills is that sometimes there's a general perception in the community that to draw a will, you really should have, a house or own substantial assets. The message that we've been sending is that really, if you're over the age of 18 and you've got the capacity, the mental capacity to make a will, you should do it, because even though, as we know, people pass away unexpectedly, and even though if you do pass away unexpectedly and you might not have a large estate, having a valid document, a valid will document in place does actually assist, your mum and dad, for example, in help, in finalising your wages, in getting a bond back from the bond authority. It may, to get if you wanted to get a grant of probate or a grant of letters of administration in the cases of an intestacy, ordinarily the Supreme Court or the probate rules basically direct that your estate value must be over $80,000. But that doesn't mean that you can't have a valid will in existence. And as I say, we see it quite regularly where we field calls, particularly from mums and dads that have lost their children, certainly well and truly before their time. But they've got a motor vehicle that they need to deal with. They've got, as I say, a bond that's been paid to the bond authority. It may mean that you're not going to get a full grant of probate or letters of administration, as I've just said, but at least you've got a document which basically is of authority and which predominantly most agencies will basically rely upon. So I'm very conscious of the time, and certainly, as I said to you, if you know somebody that wants to do a will or an enduring power of attorney, certainly I would encourage everyone to reach out to the organisations, including the Public Trustee, of course, that I've previously mentioned, to get those documents in place. So noting, Maria, sorry that it's 2:05, I'll just revert maybe back over to you and for any questions that we may have in either to either myself or Hannah or Eliza.
Thank you so much, Fiona. I think everyone would appreciate that we've had some great guest speakers here and it's been a lot of information. We are going to try and wrap this session up. So, Hannah, I appreciate that video. We might sort of, I'll post that to the end because I do really think it'd be a great thing to watch later on, and hopefully it sort of cements everything that we've talked about and why it's so important. But we did have one question in the chat, Eliza, that I think I'll get you to chat about. I may know part of the answer, but I think it's probably best if you address that. So it says the health system recognises the person responsible when decisions are made for people with ID in relation to health. Does the person responsible, like a family member, need to be appointed by the PG, being the person, or by the public guardian? So I think I'll let you answer that one.
Thank you. Thanks, Maria. Yeah, look, it's a good question. The person responsible, so when for medical treatment decisions and consent is required from someone who is unable to consent for themselves, then they look around for a person responsible, and it's a hierarchical system. So it starts off with, is there a guardian appointed? So it might be the public guardian. If there's not, is there an enduring guardian? If there is, then they're the person responsible. If there isn't an enduring guardian, it comes down to the next level, and it's a family member, or no, spouse is usually next. If there's no spouse, then it comes down to family member who's able to do it, or someone else in that close category. And so it works down that hierarchy. This is only for medical consent decisions. And then if there is nobody available out of that entire hierarchy, that's when an application to the tribunal is likely to be made for the appointment of a guardian, because an important decision, which is medical treatment decision, needs to be made.
Thanks for that, Eliza. I hope that answered the question. Did anybody have any other questions that they wanted to ask? Doesn't look like it. But we'll start wrapping up. But if you've got any other questions, please feel free to jump in. Oh, sorry, the question was, can they complete the end of life care?
No. What do you mean by end of life care? Because we're talking about an advanced care directive. An advanced care directive must be completed by the person themselves when they have decision-making ability. Nobody else can do it for them.
Okay, I work in the disability area, and we have family who will meet with the doctors, palliative care, and fill out the end of life advanced care directive or do not resuscitate orders, and they are the people responsible, but they do fill those forms out, and I'm wondering if that's legal or not legal.
That's you're probably best to contact our office. There's quite a bit in that, but you might be talking about goals of care, might be something else that you're talking about, but for an advanced care directive, a person must have decision-making ability and understand the consequences of making that, and so that to be a valid advanced care directive. But goals of care is something that is done by a health practitioner in consultation with the person to the degree that they have the capacity to understand. They are different documents. But perhaps you might want to ring our office for a more detailed discussion on this if you have further questions.
No worries. Thank you very much. Very helpful.
All right. Well, thanks. Thank you, everyone. Like I said, we'll send out some more information about this session, more information about how you can prepare those documents. But I really hope today's main takeout was to prepare the documents and make your wishes known and understood so that they can be followed and respected. It is an act of love, not only for your loved ones. It also helps the legal system, and it's just gives you a lot of peace of mind in making sure you've got those documents all sorted. So I greatly appreciate everybody joining us today. We've got some, I'm just about to send out a survey for people to fill out. I would greatly appreciate your feedback. We'd love to be offering sessions like this more often, because I believe it is really valuable information for the community. But we'd love to know how we went today and what we can improve, or, you know, what really sort of resonated with you. So thank you very much, everybody. Thanks for your time. Please fill out that survey and get in touch with us if you need any further information. Thanks, everybody.
Thank you. Bye.
Thanks, Maria.
Thank you.
Thank you, Maria.